Here's what I'm going to cover today. First part of the slides, nuisance cases. I'll give you an update of what's going on in Iowa, agricultural nuisance cases. Secondly, we'll talk about some DNR regulation issues. We don't have a lot new this year. Come back next year, we will have a new set of regulations that are being worked on. Don't get too worried here. I think the set, there are should be some good things in there. And be careful when somebody tells you there's a good regulation coming. But won't be a major issue, mainly cleanup work from the last time that DNR did an extensive set of regulations was in 2010. So this will be 2016, 27, we'll get her done in 2016 probably. But we'll be talking about a lot of that next year. Then today, I want to give you an update on the work plan inspections, how those are going. We have, I always pick on him, it's time to do that. Gene Tinker, raise your hand in the back. Gene Tinker with the Iowa DNR Animal Feeding Operations Unit Coordinator. Gene is always a good sport, comes here, and when I feel like it's time to pick on him, I call on him. So we appreciate you being here, Gene. Then I want to talk about something today that's not directly a livestock regulation issue. I said not directly, and that is the Des Moines Water Works lawsuit. I'm sure you've all heard about it. That's towards the end of your slides. And then the two slides I added, any of you with livestock truck washes, any of you that have a truck wash or are thinking about one, just this past legislative session, a bill was passed to change a little, it moved the regulation of livestock truck washes from the industrial permitting section over to the animal feeding permitting section, and then as part of that, we have a couple of exemptions that help out the smaller truck washes, and we'll talk about that. Those slides are not in your handouts. They're the last two slides here, and we'll cover those today. Plus, these slides will be put up on the Pork Producer website within a week or so, I believe, with the presentation. If you really, really want to hear me again, you can listen to that one. And that is what I plan on covering today, so let's get to it. And, as always, a couple of things. One, if you've come in and don't have a copy of the slides, they're on the chairs there in the back. And number two, as those of you who have heard me speak before, please, if you have a question, ask it at the time you have it. I don't believe in waiting till the end. I like to get a discussion going here today. And what I'll do when if you ask a question, I'll repeat it. One, to make sure I can put it in a form that I can answer, or at least better dodge. Just kidding. And then two, so that it shows up on the tape that goes on the internet, so we can, so those that aren't here today listening to this presentation on the internet will be able to understand what I was answering instead of just hearing my answer alone. With that, we'll go ahead and get started. Agricultural nuisance cases. I'll give a little background on what they are. I think a lot of you know that, but first I just want to give you an update of where we're at. The good news, no agricultural nuisance cases, and primarily livestock and primarily swine, when I talk about them, went to trial in 2009, 10, 11, 12, or 13, or 14. Well, that string was broken. Well, before I get to that, in 2008 was when we had the last three cases prior to that string of years. And in all three of those cases, 2 cattle and 1 hog, and we've talked about them in previous years, the juries found that there was no odor nuisance and found in favor of the livestock producer. Well, that string was broken in several ways this past year. In 2015, in Powesheik County, a case went to trial, 2,490 head swine finishing site, one plaintiff who lived between 1/4 mile northeast of the site. The jury in Powesheik County, in February 4th, returned a verdict of $525,000 against the livestock operation, the hog operation. And this is all public record. This is all public record. What I'm reporting to you, the jury verdict was $100,000 in loss of past enjoyment of their property and $300,000 for loss of future enjoyment. So it was future damages, $300,000, and $125,000 for loss in property value. This case is on appeal to the Iowa Supreme Court. Obviously a case that is not what we as livestock producers wanted to see. And again, it's on appeal right now to the Iowa Supreme Court, so stay tuned. We'll probably be talking about that appeal next year. So what do we have pending in the Iowa courts right now? I've been following nuisance cases for the Iowa Pork Producers Association since around in 93, 94. Since then, we have right now as many nuisance cases on file in Iowa that I know of anyway, and there's no central reporting system where you can type in the word nuisance and find it. It's you kind of got to know what you're looking for in the court online system, but I'm pretty sure I'm close that we have as many as we've had that I know of at any one time. In 2003, if I didn't go back and look this up, but if I'm remembering right, we had around 13 to 15 on file at any one time. We saw a spike then it went back down, and as I reported, we had cases on file in those years of, those years I listed on the first slide. But none actually went to trial. We still had some on file during those years, but it was a pretty small number. Now we've seen it spike again. We have 12 on file right now, and I'll just run through those here in this next slide. Okay. And what I'm showing you here, again, this is public record. I don't give the producers' names or the neighbors' names. They're public record, but I've found it's just better to report to you what's going on out there in the county that it's in, and then if you want more information, I'll be glad to provide to you what we have from, again, what's a public record. We have a case where trial will begin on February... Pardon me. Trial will begin February 1, next Monday, in Wapello County. That's a swine finishing site, and a jury trial will begin in Ottumwa. Then we have a case in federal court that arises out of Henry County. The trial is set for March 21, another swine finishing site. Buchanan County. This is a cattle feed yard, less than 1,000 head. It is set for trial on April 20th, but I think I can report to you with fairly confidently that has been continued, so that trial will be kicked back to a later date. Then we have a Powesheik County case, 2 swine finishing sites actually, and that case goes to trial May 31st, and then back to Wapello County for a jury trial August 15th. So as you can see, we have 5 on the list here. 4 of those are still on the list to go to trial this year, so it's going to be a fairly active year. This one, February 1 in Ottumwa, Wapello County, it sure looks like it's going to go to trial. We're only a few days away, and the attorneys are preparing as we speak, and that'll be at least it looks like a 3-week trial. So stay tuned. I don't know how much the media will report on that, but we certainly will keep an eye on it for you on behalf of the Iowa Pork Producers Association. Okay? Then, beyond that, we go to cases that have not been set for trial yet. I guess we do have one. I'm on slide 4, and that is Powesheik County. Next January, a year from now, there's one a swine finishing site set for trial. Then we go to, thank you. Then we go to, Then we go to Adair County, Union County, Davis County, and Lynn County, where cases have pretty much just been filed. Those cases probably won't go to trial until sometime in 2017 to late 2017. Yes, sir. The question was my statement. Let's go back. The one beginning February 1 here on slide 3, I stated it'd probably go 3 weeks. The judge has set that amount of time aside, and the reason is the number of plaintiffs, those suing. There's, I believe, 10 plaintiffs going to trial in that case. And this case is somewhat unique. And I forget what I've said before, but many of you have heard me say when an attorney uses the term something's unique or interesting, hang on to your wallet, because that means it's going to take a lot of time and a lot of legal work. You don't have to hang on to yours. I don't this one, but This case, why is it going to take so long? We have a lot of plaintiffs. There'll be experts. The judge has indicated, and I'm not an attorney in the case, but we're keeping an eye on it, and I am an attorney along with my partners in another case that's kind of a companion case, so I've been following the court's rulings closely, which, again, this is all public record. The court has indicated the first week will pretty much be taken up with jury selection and pretrial motions, and then the trial will actually start the following week, February 8th, is my understanding. And again, with the jury involved, sometimes they don't go as long a days as you might otherwise, so it tends to get strung out, let me put it that way. But with the number of plaintiffs and witnesses, et cetera, that's the estimation that it'll go about 3 weeks. I also said this case is somewhat different. This case is what's called a bellwether case, and that means, and don't quote me on the exact number, but there are a number, I think there's somewhere around 30 plaintiffs in this case, and what the court has done in this case and the one that goes to trial in Wapello County August 15th, the bottom one on the list, the court has said since there are so many plaintiffs, those suing, each side got to pick a certain number of plaintiffs, both the plaintiffs' attorneys and the defendants' attorneys, and they're called bellwether plaintiffs. They go to trial first. And then depending, after that trial is over, then another trial will be scheduled for more of the plaintiffs, with the thought being that after you go to trial with one set of plaintiffs, that there might be a settlement as to the others. Okay? It's called, you don't see it very often. This is the first case I've seen in the ag nuisance area that has used the bellwether approach when you have so many plaintiffs like that. Again, this is in Wapello County. It's in the Batavia area is where the case is originated. Okay? That's why it's going to take so long, and my answer probably took as long as the case is going to. So we'll try again. Well, let me move through some of this, and then I'll try and summarize. Yes, ma'am. The question was, can I talk about the facts of the case and why are there so many plaintiffs? I'll tell you what I know and what I can. There are several small towns involved there where we have a fair number of people located. I can't really tell you why there are so many involved as plaintiffs. I guess that'll come out at trial. I can tell you from what I know that some of the plaintiffs are several miles away. Some are a lot closer than that. I'm trying to be as forthright as I can about the facts as I know without telling you something that might not be correct. But to the best answer I can give you as to why there are so many plaintiffs, we have several small towns there, and quite honestly, it's been a very controversial issue when these hog operations were in the community. There was a lot of unrest in the community in the year or so leading up to the construction of these hog buildings for those two cases. So it's been a pretty hot topic community-wise. That's the best answer I can give you as to why there are so many. But good questions. I don't blame you for having those questions. We attorneys kind of just speak in these terms like bellwether and plaintiffs and all that sort of stuff. I'll do my best to put it in, not that you're not bright individuals, you certainly are, but you raise hogs and you want to know what's going on out there, and I want to give you the best information I can. So what I'm here today to tell you is what's going on, what are we seeing in the court system, and what can you do as producers to deal with that. And that we get to my next slide, slide 5. What are ag nuisance cases? What do we normally see in these cases? What are people suing about? Odor is the number one issue by far. An ag nuisance case is about unreasonable interference with the use and enjoyment of property, and anyone filing a nuisance case is essentially claiming that odor is an unreasonable interference with them being able to use and enjoy their property. And that is what pretty much a jury has to determine. I also have there on slide 5 flies. In many cases, not all, but in many cases, flies will be alleged as a nuisance also along with the odor. But usually it's not the primary issue with hog operations anyway. That's by far odor is the bigger issue. The third bullet point I have there on my slide is the normal person standard. Iowa, like many states, a lot of the law on nuisance is not anything you'll find in the Iowa Code. It is what judges have determined over the years, the Supreme Courts of all these states. And nuisance has a lot of this, the unreasonable interference, that's in both the Iowa Code and in the court decisions. But the Iowa courts have determined and ruled over the years that when someone brings a nuisance action, what the jury is to look at is what maybe not that individual person, what they believe is the problem and whether the odor is a problem or not. And by the same token, not whether the livestock producer believes it's a problem or isn't a problem. Both of those have a vested interest in this. The jury is supposed to look at it, and they will get a jury instruction that says you are to look at this as a normal person living in the area would consider this. And essentially what I believe that means anyway is to kind of put aside the vested interest both sides have and look at it as independently and unbiased as they can. Now, any of you have been on a jury in any kind of case know that when you go in that jury room, it's a lot of things come to play, and recognizing the jury instructions is one of the hardest things you do. But that's what this jury in Wapello County will get a set of instructions like that, as do all juries I've seen in the state of Iowa in nuisance cases. That's why I bring that normal person standard out, to show that they are to look at it kind of, again, the jury is to look at it, remove themselves from what, they're to listen to the testimony, of course, but they're to focus on what is called a normal person standard. The next one, the bullet point, who was there first? There's three elements to a nuisance case. I won't go into those that the juries will look at, but one of those, and probably the courts have said the most important, is who was there first. I've been working on nuisance cases as an attorney since 1994. I don't know how many cases I've either followed or been an attorney in, and I'm not here to impress you with numbers. I'm here to tell you I've had a number of them in those 20-some years. I've had one case where the livestock producer was there first and got sued, even though the neighbor moved in later, and the livestock producer won that case. The who was there first, in the cases I've had anyway, and I think in all of those cases that you see on that list, when you get a lot of plaintiffs like that, 20 or 30 or 40, then there's usually somebody in there that moved in later, but by and large it's a result of people who already live there and the livestock operation is built. So that factor, the very important factor of who was there first, usually goes to the side of the plaintiffs, at least in the cases I've seen. Then what do we see in these cases? Fact witnesses and expert witnesses. I often have producers ask me, well, the neighbors have to prove it, right? Yes, they have to prove it. But what is proof? When a witness gets on the stand, whether it's for the defendants or the plaintiffs, and raises their right hand and says, the odor is terrible, I can't stand it, it's ruining my life, or the witness gets on the stand and says, I live in the country, I realize it's Iowa, and I don't think it's a problem. Do I smell it sometimes? Yes, but I don't think it's a problem. Whatever that testimony is, that's the proof that is put in front of the jury. Then you have expert witnesses. Expert witnesses are those that can give an opinion, such as a scientific opinion or an opinion about property value. And they will give an opinion, and both sides usually have their experts as to what their opinion is about odor. They may do some monitoring and modeling, as we see here. There will be experts that will talk about how the sites are managed, etc. And then I talked about, in some cases, property value will be testified to as what is the value of that property. Those are I've just told you in about, a little more than 5 minutes that'll take approximately 2 to 3 weeks here in the first part of February. Okay? All right, I think I've covered that. Slide 6. Steps to help avoid a lawsuit. what I'm here today, I wanted to give you a background on nuisance cases, but then I also wanted to talk about, hopefully, how you or anyone else can try to avoid one. Now, I'll be the first to tell you that this list I give you, you can do every one of these things and be fine, or you can do every one of these things and still get sued. Nothing is, there's no magic bullet that I know of. But these are steps you can take. They don't apply in every situation. The fact that I have something on the list there does not mean that if you don't do it, you've got a problem, because it may not apply in your situation. Location, location, location. Separation distance is very important, but as I said, in some of these cases, we're seeing people sue up to a couple miles away. How you can prepare for that, I'll have to have a discussion with you, because I'm not sure I can give you that answer. But don't give up. You need to always pay attention to separation distance. Generally, the further away you can be from neighbors, the better off you are. But I've seen cases where they have neighbors close and they're fine with it. So again, it's just, as you know, nuisance is a very subjective standard. All we can do is look at these factors and do our best. Separation distance, and also look at, as someone, maybe it's Jay Harmon's here from Iowa State University. Jay, raise your hand. I don't know if you said this or Steve Hoff said it. Somebody said all separation distances are not created equal, because we have the prevailing wind issue. The prevailing winds in Iowa, as I understand it, are in the summer, the warm weather months, and you don't need an attorney to stand here and tell you which direction the wind comes out of. But this is what's presented to juries. The prevailing winds in Iowa are out of the south, and the information I've seen, contrary to some popular opinion, even a little bit to the south-southeast. Jay, do you agree with that? Jay's nodding his head up and down. Often we think that the prevailing winds are out of the south-southwest. Jay, is there a big difference between, it's not a marked difference, would you say? Yeah, and what Jay just said is predominantly south to southeast. There's obviously some from the south-southwest, but again, this is a little different than many people think. So when you're citing that livestock operation, not that you shouldn't pay attention to all neighbors, but you should pay particular attention to those located to the north to a little bit northeast of your operation, because they are the ones that are in the prevailing wind direction. So that's where you want to look at that separation distance and get it as great as you can. Topography has an effect on that. Tree buffers. I'm a big believer in these, and I'm not the only one. Rita Cook is here with the Coalition to support Iowa's farmers, and the Coalition has a tree planting program, right, that you work with farmers on. So if you have a question or want some assistance with the tree buffer program, please contact the Coalition. Jay Harmon has done a lot of work with this, along with others at Iowa State. I'm a believer from a lawsuit standpoint of getting fast-growing trees. And I'm not selling trees here, okay? Don't have an interest in any of these companies, but os trees or some other type of fast-growing tree. I call them tree purists, jokingly. Nobody ever gives an attorney a hard time, so if I tease somebody about being a tree purist, I think it's fair play. But anyway, these fast-growing trees have been called the James Dean of trees. Live fast and die young. Well, I don't care. I like that tree up there 10, 20 foot tall within a couple years. The os trees, you've seen them around livestock buildings. I think that's a big advantage. And then plant some slower growing trees with it to pick up because those trees do die out. We see that, right, Rita, in your plans, etc. But a fast growing tree because the reaction you're going to get from neighbors who may not like the idea of your hog building or going in is that, well, trees are fine 15 years from now. 20 years from now, that'll look great. What do we do till then? Get some fast-growing trees in there. Within a few years, you'll have a pretty good shelter belt there. And the research shows that does provide odor protection. Ventilation and exhaust fan management. Important to properly ventilate those buildings. That goes along with the 2 bullet points down, the clean pigs and buildings. I'm a believer in handling these cases that Part of the criticism is you spend money as producers on making sure the pigs are comfortable with all that money you spend on ventilation and ventilation systems. What do you care about the neighbors? Well, you do care about the neighbors. Yes, you're keeping the pigs comfortable, but those comfortable pigs are clean pigs, and clean pigs have less odor than uncomfortable pigs who are dirty pigs. So don't sell yourself short on what you do for ventilation and exhaust fan management. Along with that comes biofilters. Take a look at, in some cases, you should take a look at using those. Iowa State has done a lot of work on those along with other institutions. Again, they don't fit every situation. They aren't necessary in every situation, but in some, producers should take a close look at them. Mortality handling. I'll have a few slides here on composting. Mortality handling is very important when it comes to hopefully avoiding a nuisance lawsuit, because let's be honest with ourselves, those are dead pigs laying there. We're starting with a premise that a jury is not going to like to hear. Dead pigs. But what you have to show is that's part of raising livestock. It happens. Everyone who raises livestock has something die, and that you handle them correctly, either rendering or composting, and there are other ways too, but those are the two we primarily see anymore, and I'll talk about composting in a minute. And then overall operational environmental management, I call it including neighbor awareness and neighbor communications. Communicate if you can. Again, the coalition will be glad to help you with that, and there are others. I often hear from producers say, it's not going to do any good to go talk to those neighbors because I know they aren't going to listen to me, they're upset, etc. And you may be right. You have to make that decision, but going to talk to them is something that if you don't do it, they'll always be able to say you didn't do it. If you try, then so be it. You did your best. But again, you have to make these decisions in each individual situation. Okay, protection for the producer. Slide 7. Insurance. Just like trees, I'm not selling insurance today either, folks, okay? But insurance is a form of risk management, and you need to make this decision as a producer. I start with a slide that standard farm liability policies normally don't cover nuisance because of several exclusions in insurance policies, primarily the pollution exclusion. Don't give up. The next slide we talk about special policies or riders or endorsements, if you want, if you will, that are out there. But looking at the standard farm liability policies, my advice would be do not depend on that if you truly want some nuisance protection. However, there was a case in 2013 in Illinois where the court found that there was coverage that, as I have here on the slide, that odor from hog manure was not traditional environmental pollution that would have been excluded under the policy, even though the insurance company said it was excluded. They appealed to court, and the court said, no, you do have coverage. My point would be, if you know you want coverage, don't depend on that. Don't depend on having to appeal and get a court to say you do have coverage. As we'll talk about in the next slide, get the coverage as best you can. We had a 2014 Wisconsin court decision that went the other way that said manure that polluted a well, that was pollution that was coverage was excluded. I think the two cases are quite a bit different in their facts. But again, my advice, slide 8, there are special policy endorsements that do provide nuisance coverage. There are companies that offer that. I believe there are some upstairs at this trade show. If you're interested, stop by and talk to them. I guess what I will say is insurance is a contract. There you see in the middle of that slide, carefully review the terms and make sure that you're getting what you believe you are getting and what you are paying for, okay? If the premium sounds too good to be true, it may well be. You may find out when the you-know-what hits the fan, you may not have the coverage that you thought. So, we all do this, but the call I hate to get is from the producer who said, boy, I thought I was getting this coverage, and now they're telling me I don't have it. Pin them down. Like a lot of you that I work with out there, you pin me down when I won't give you a straight answer, and I appreciate the fact you do that. Pin the insurance people down and say, am I covered? no ifs, ands, or buts about it. If that neighbor over there sues me for odor, for a nuisance, and says that and their attorney says that I am unreasonably interfering with the use and enjoyment of their property, am I covered? Period. I need to know that. That's what you want from a policy. Okay? All right. Now let's talk about nuisance defense laws. In Iowa, this is a fairly short discussion because our Iowa Supreme Court has ruled there at the bottom of slide 9 that our laws adopted in 98 and 2004 are unconstitutional. Only state in the country that's happened. Stay tuned. There's going to be more discussion about this in this case coming up. In these cases I have on the list, including the one starting February 1. There will be probably some legal appeals there. We don't know for sure, but that'll be an issue of whether there's any nuisance defense coverage from Iowa's law. Right now, we don't. Again, the court has ruled it to be unconstitutional. Some good news if you live in Missouri and you're here today. The Missouri court on April 14th of 2015 found that their nuisance defense law, which is a very good, a very strong law in my opinion, protecting producers, was constitutional. That decision is almost 180 degrees from the Iowa cases. Don't ask me why. That's what courts do. But hopefully we here in Iowa can use that Missouri case to maybe help with our law here in Iowa. And so I guess all I can do say is stay tuned there. Slide 10. This talks about what the facts were of the case where the court found it to be unconstitutional back in 2004. I won't spend any time on that. Okay, I've used about half an hour here on nuisance, which I intended to do. Any question about nuisance cases, what we have going on in Iowa, what I've covered here today, and what hopefully you can do to help avoid such a lawsuit. All right? The question was, is there a statute of limitations on a hog building and a nuisance case, right? I wish there were a short answer to these questions. There is not a short answer to that question. That is being batted around in court right now. The statute of limitations for property damage, anything where they argue damage to their property value, etc., is 5 years. That's clear in the Iowa law. The statute of limitations for personal injury type damages, I can't sit out on my deck at night, etc., that kind of thing, is 2 years. Okay? That is clear. What is not clear is how does that apply? If nuisance cases are what we call a permanent nuisance, that is, they get one lawsuit, like the case that I told you about in Powesheet County in 2015, the jury found that it was a permanent nuisance and awarded future damages, then the statute of limitations would apply, and any operation older than 5 years would be pretty much out of the woods, okay? But the courts have also ruled, and in this case coming up in February 1, the court has ruled there that it's what we call a continuing nuisance. Not a permanent nuisance, but continuing nuisance, which means that the statute of limitations never actually runs, that we call it. It's just that whenever the case is filed, they can go back that many years. Okay? I know your eyes are going to start glazing over, but this is what we're wrestling with here. The Iowa Supreme Court found in 1996 that odor nuisances were permanent nuisances, which gives us a line in the sand. Anything generally you can say after 5 years, and if you don't change anything after that, then that would be the cutoff for lawsuits to be filed. However, that's being challenged now, and this court just ruled that it would be a temporary nuisance under the facts of this case. That means the statute of limitations never expires. You just look back that period of time for damages. I hope that makes some sense, but stay tuned. Here's what I say to producers. The longer you're there without problems, obviously the better off you are. And if it's a permanent nuisance, that would be the best for us, because that means after 5 years you're out of the woods. You can't quit doing a good job, but you are in a much better position. Even under temporary nuisance, the longer you're there, the better off you are, because arguing to a jury after you've been there 15 years and that neighbor's been there 15 years, and all of a sudden they decide to sue you, and I just picked that number out of the air, sort of, and the longer you're there, even though they may be able to sue you, and nobody wants to end up in court, but that's a good argument to make to a jury of, I've been here for 15 years, you've never said a word, or you haven't sued, and now you're suing me? Even though you're still being sued, even though you're still in court, it still gives you a very good defense. Okay? Yes, sir. The question was, in these cases, are all of the plaintiffs individuals, or has an incorporated town ever filed suit? I have seen people in a town file suit, but no, it's always individuals who are plaintiffs. I've had, I got to think, in all those cases, I've never seen an incorporated town become a plaintiff in themselves. Okay. Now, well, let's leave. Yeah, in these cases, individuals are who file the suits. Okay. They may live in the town, but okay. Any other questions? I know we're taking a lot of time on this, but this is important. All of this is important, but this is critical now with the number of cases we've seen on file, and trying to give you some help in hopefully avoiding that. Like, I can guarantee you every producer on that list of 12 sincerely wishes they weren't on that list, and sincerely believes they've done everything reasonable to stay off that list, but they're on it, and they're doing everything they can to hopefully get it resolved without going to trial. Okay? Composting. Moving to slide 11. We're going to kick her up a notch here. Let's see, I go till 10:30, right? So, we got a ways to go here, but we've got some time. All right. Slide 11, composting mortalities. Why did I put, these are DNR rules that I have up here. But the reason I have that slide here is, one, in the nuisance cases we see, composting is one of those targets. Again, think about it, folks. I'm not saying composting is a good thing to do. It returns nutrients to the soil from the dead, from the mortalities, the dead pigs. It helps you with biosecurity, etc. It's organic, right? We're returning that stuff back to the soil, etc. It's a good thing to do. But in front of a jury in an odor nuisance case, what will be stated is, ladies and gentlemen, what's in that pile under those wood shavings or those corn stalks? Dead, rotting pigs. That's what's in there, which is true. The image of that is something you have to get by as a producer to show that it's not causing unreasonable odor and it's not causing an unreasonable amount of flies. So you need to do it properly, both from a nuisance case standpoint, and we're going to talk about the DNR work plan inspections here after a bit. And when DNR comes to do their work plan inspections of a confinement hog operation, the only thing that's really outside there, assuming you have deep pit under slat storage, is that compost pile. It will get a lot of attention from those DNR inspectors. So, for that reason, what we have here on slides 11 through 14 are the DNR rules on composting. On the first slide, I have the distances laid out there. Minimize ponding, etc. Probably the main point is bottom of slide 11. An all-weather surface doesn't require concrete. Most do use concrete on their composting sites, but it's not required. It has to be an all-weather surface. Slide 12. 3 bullet points down, I guess, is what I want to focus on here. Not that the other things aren't important, but mortalities may be composted off-site at another livestock operation without a composting permit, okay? So you can take mortalities from one site to another. There's no restriction on distance, and you do not have to be from the same owner or operator. That's what's in the DNR rules, okay? Slide 13. In transporting those, the vehicles must be constructed to prevent release of mortality-contaminated materials, and you must use the most direct haul route that avoids biosecurity risks. Maybe you've heard me say this before. If the most direct haul route is through town and you swing by the Burger King to pick up something at the drive-thru, pick a different haul route, okay, folks? All right? Yes, use the most direct haul route, but you know you got to use some common sense here as how you get there, but you can haul them between sites. Slide 14, second bullet point. That's probably one of the most important things here is the cover, both from a nuisance case standpoint and from DNR regulation. If there's a leg sticking out, any part of that carcass, that means you probably don't have the 12-inch bulking agent cover and 6 to 12 inches between carcasses and a 12 to 24-inch base. I think this is extremely important in your composting pile to keep these covers there, especially the 12-inch cover, because that you don't want to see anything. You want to have it adequately covered, because then it also obviously helps with the composting process. I will say, and if you want to really impress your DNR inspector, Gene's here, if you really want to impress that field officer when they come out on the work plan, tell them that McAfee said the rules require 6 to 12 inches between carcasses, and you want them to measure that to make sure it's there, okay? Gene's leaning over. He's not smiling much, but you can tell them that and see what their reaction is. They'll probably say, have McAfee come out and measure that, right? I'll be glad to. Give me a call. Okay. Now, that's composting. That's slide 14. Now, any questions on composting? Those rules haven't changed. That's not why I put them in there. I just thought we should emphasize it given those other areas. Slide 15. We're kind of jumping around here, but here's an area that has received some attention this year because of our weather, and that is manure application on frozen or snow-covered ground. And these are slides 15 to 20. I don't know if you're in this situation. I hope you're not. And in the interest of time here, if you need to apply this winter because you couldn't get it on last fall, first of all, the restrictions on snow kicked in December 21. Frozen ground, if you have ground out there that's frozen now but not snow covered, you have, a few days left before February 1 gets here when the frozen ground restrictions kick in, and we show the definitions there on slide 15. But if you couldn't get it on last fall because of weather and you don't think you can make it till spring, this is going to be a very tough situation. And I'll be glad to bring Gene into this if he wants, but I've had a couple of clients and producers contact us through the Iowa Pork Producers Association who have said, the applicator couldn't get there last fall. Yes, we had great weather up in, you tell me in your part of the state, had great weather up to a point, and then it turned, rained, etc. If the applicator couldn't get there, you may not have got it on, and if you've got a building where you can't make it till spring, what do you do? Well, the law says that you can apply in an emergency, and I gave you the exemptions a couple slides back. It has to be generally a liquid manure hog site with an MMP, okay? If you can't get till spring, you need to be thinking about this right now because you've got some issues to work through. The law says it's an emergency due to unforeseen circumstances beyond your control, unusual weather conditions. Okay? Second bullet point up. Well, I've had a few conversations with DNR, and DNR is questioning whether we've had unusual weather conditions that would warrant an emergency. If you think you need to use this provision, don't wait until the pits are running over to check with DNR. This next slide, where you make a telephone call, etc., you need to plan ahead. Now, on the other hand, I think some will tell you, don't get too far ahead of yourself because we want to make sure you actually have to do it. But don't wait till you have I don't want to use the word emergency, but don't wait till the pits are brim full. Contact your local DNR field office. You may well be told that, we don't really think we had unusual weather conditions, but, and I'm choosing my words carefully here, Gene's kind of smiling at me. I think what you need to do, we'll see if Gene agrees with me, you need to then put together your written documentation as to why You believe you have an emergency. Get something from your applicator to say the applicator couldn't get there. If it's weather, get some weather records put together to show that in your area, how much rainfall you had, etc. Get some documentation put together and provide that to DNR. Just plan ahead for this, because DNR is being very careful in granting the ability to apply on snow-covered or frozen ground. And I think quite honestly, I think you would agree, this is not something you want to do. It is something you have to do, because if you don't, the pits are going to be too full next spring. It is not a valid reason, according to DNR, to say the landowner doesn't want me out there next spring because of soil compaction. That won't work. You have to have some information, some documentation to show its weather conditions. Gene, anything to add? I'm going to repeat that. No, Gene just said I did good. So again, it's a tough decision for DNR, and it's a tough decision for you. But I believe that exemption is there in the rules and in the law for a reason. You just have to show you qualify for that. And if you do that, I believe DNR will work with you. But you need to plan ahead. Okay? All right. Any questions on winter application? I hope you don't have to do it. I'm going to skip through slides to 21. Slide 21. Okay, this is on animal unit calculation. And these are slides 21 through 26. And I don't know how much time I will spend on this morning. I've covered this pretty extensively in years past, and if you haven't been here in years past, that doesn't help you. What we're talking about here is deciding and calculating what the capacity of your buildings are, and making sure you meet that capacity so you're in compliance with DNR rules. All right. We had animal weight capacity, and now we're under animal unit capacity and have been since 2002. I'm not going to spend any time on animal weight capacity here today, although there are a number of sites out there that are still under animal weight capacity. If you have such a site, have a question, please look me up or give me a call. We'll be glad to discuss it. I'm going to go to let's go right to slide 24. I think the calculation is something that you're familiar with, what the animal unit factors are. I've got those in the slides. The question is, some of you in wean to finish buildings will double stock, okay? You can do that. But what is the animal capacity of those buildings? Well, 55 pounds is the cutoff point, and as I state on slide 24, must double-stocked or overstocked pigs be removed before any pigs reach 55 pounds or before the average is 55 pounds, because once they get to 55 pounds, then your animal unit factor goes up to 0.4. So the short answer, and I shouldn't even said that, there is no short answer. The answer is neither, because animal units is calculated based on the number of pigs weighing more than 55 pounds and the number weighing less. So you could technically have a 200-pound pig in there and all the rest below 55 pounds, and you'd be fine because you calculate the number over 55 and the number under. It's not an average weight, and it's not when any pigs reach 55 pounds. Here on slide 25, I go through some numbers, and I'll poke fun at myself anytime a lawyer does math. Be careful, but I'm pretty sure these are correct. And I know some of the ISU Extension people have done some work here. Some of you have done some work here. You can calculate how many pigs can you have over 55 pounds and still be in compliance with your animal unit capacity numbers. And I lay them out there on double stocking, the factor there, and on it's a factor of 0.33, and even on triple stocking, etc. My main point is, just because you have some pigs over 55 pounds, you're not out of compliance. Do you want to be absolutely safe and not have to worry about being out of compliance? Then don't let any pigs get over 55 pounds before you take out those double-stocked ones, etc. But if you can't, you can have some pigs over, okay? Any questions on that? All right. What are your options? Usually when I go through this in a presentation, there's somebody who talks to me later that says, okay, I'm pretty sure I'm going over my capacity pretty regularly. What do I need to do? Well, your options are, and I lay those out there on slide 26. If you're a SAFO, if you build as a SAFO below 500 animal units, then what are your options if you want to go over 1,000, over 500 but stay under 1,000? You need to get an MMP and a CDS, construction design statement, and again, work with your either your builder or your consultant on this. The next category, if you build in between 500 and 1,000, and now you want to go over 1,000, you're going to need a construction permit. You should already have the CDS, and the matrix is going to be the issue there. And then if you have a construction permit, but you're going over the capacities, you would need to get a new construction permit. Gene, I'm going to pick on anything to add to these calculations and what they should do. He's shaking his head no, so we'll move on. Okay. Confinement operations 1 or 2, these are the distances that you need to be between operations to be considered separate, so you don't have to add them together. Unless there are any questions here, I'm going to move through these slides. We're to the point of the presentation where I'm going to probably move through some slides, get to the work plan, get to the Des Moines Water Works to get to this. So hang on with me here. I want to move through these slides. Let me make sure I'm not missing something here I had marked in my notes as critical to discuss. But let's go to slide 35. Okay? We're leading into the work plan now. If you have a mixed site, that is usually what we see, hogs in confinement, cattle in an open lot, circle this slide, number 35, as to, now we're talking about whether you might have some issues, whether you need what we call an NPDES, a discharge permit, because if that hog building puts you over the large CAFO threshold, which is 2,500 head, and then you have a small cattle feed yard there that's an open lot, by the fact that your hog building kicked you over the threshold, now that cattle feed yard is required to be no discharge in effect. It's made you a large CAFO. EPA focuses on these sites. DNR has taken a close look at them in their inspections. If you have this situation, talk to your consultant, give us a call. We'll be glad to lead you through what you should be looking at. Okay? All right. I'm going to go through the next slides here. I want to get down. Let's go on over to slide 39. Again, I wanted you to have these slides in case you have questions. As you look at them, give us a call. Slide 40, accidental discharges. If, and I hope you never have to make this call, but if you have a discharge, that doesn't necessarily mean, by discharge, a spill. I hope you never have that situation, but if you do, handle it immediately, report it to DNR, work to contain it, and then you need to emphasize with DNR what you're going to do to prevent that from happening in the future, and then that should mean you don't have to get an NPDES permit. This is a critical issue when EPA looks at things. Okay? All right. Let's get on over to slide 42, the DNR work plan. And I do want to spend some time with this. Gene, do you mind me asking, as I can tell from the reports that DNR has made to EPA, the work plan inspections are right on target, right? Anything to, I mean, it's a 5-year plan and 20% per year, and you're maybe even a little ahead of schedule? Okay. What Gene said was last month, that's the halfway point in the 5-year period, and you're at 52%, you said? So, now, I'm at slide 44. First of all, I would imagine most of you, or a lot of you in the room, have had a DNR work plan inspection, and generally, what I hear, the inspections have been going well. Haven't had any big issues. On slide 44, I give the priority that DNR was to conduct those work plan inspections. And this was not hard and fast. Some of you at the very bottom there, medium-sized CFOs, and that would be your 1,250 to 2,500 head buildings, your MMP buildings, those that aren't required to have a construction permit but are required to have an MMP and a construction design statement. I know some have already been inspected, but they are the last priority. I assume that will be more the focus as we go forward now, Gene, in most of the field offices. And he's indicating yes. So, a few years ago, well, it would have been 2 years ago at Port Congress, we first had the discussion about the DNR work plan inspections. I probably told you that you medium-sized confinement operations are down the list a ways, not that you couldn't be inspected because DNR will sometimes take them out of order, but you're not at the top of the list. Well, the time has come, folks. You are now probably at the top of the list for what's remaining. So if you have a 2,400 head confinement building and haven't been inspected yet, you're going to be hearing here fairly soon. And what you will hear, and let's go ahead and move to that, it doesn't necessarily mean, I'm on slide 46, if you're a medium-sized operation, they will do a desktop assessment like they do for all sites, and you may well get a letter saying there will be no on-site inspection because you don't qualify. I went too far. Whoops, I keep jumping back and forth. That bullet point that says the confinement operation is less than a quarter mile from and draining toward the water of the U.S. If you're further away than that from a creek, etc., you may well not be inspected, but just a desktop assessment. But if you are inspected, then we're looking at slide 49. All right? Here's what will happen. And probably a lot of you know more about this than I do, but this is what the work plan says. 1 to 3 days before the inspection, DNR will give you a call. I think they've been contacting you much earlier than that. You should have your records available. The key point there on that slide is DNR will not enter confinement buildings, and we're 2.5 years into these inspections. I'm not aware of it any time where DNRs went into confinement buildings. Gene? Gene just said his own, so that's your problem, Gene, not ours. Anyway, they will not go in confinement buildings, okay? They must follow your standard biosecurity policy, and if none, they will follow their own. Those of you who have heard me give this talk before, I'll say it again. Have your standard biosecurity policy in place, but your standard biosecurity policy cannot be that DNR is not allowed in my bill or on my site, okay? That won't work. That can't be your standard policy. Gene, go ahead. Okay, Gene made a good point. If they call to do an inspection and you've had a break of, well, even PERS or PEDV, in the neighborhood even, not even at your site, let them know and they will reschedule you. Okay? Important point, because they're not interested in being any part of that problem. So if you've had a disease outbreak in your neighborhood, let them know and they'll reschedule you. Okay? Thanks, Gene. All right. My point on slides, the next few slides, you know they're coming or at least you're going to be assessed. My point, and I'm not going to belabor it, I keep jumping around here, slide 50, do a self-audit of your operation to determine if you think you have any problems. If you do, any compliance problems, if you should have had a permit and you don't, or whatever, your MMP, maybe you don't have an MMP. If you discover that and file a notice of self-audit, and this is the part where I say it's not an official Eldon McAfee environmental regulation presentation unless I mention doing self-audits and then my slide on open burning. I have to have those slides in if I give this talk, because I'm a big believer in self-audits. DNR is a big believer in the self-audits. I've done a lot for producers over the years, as have others, and they help you get into compliance and they help DNR get you into compliance, because that is what DNR's goal is, to have you in compliance with the rules. So if you discover before the work plan inspection you're not in compliance, get a hold of someone to help you with this self-audit notice before DNR gets there, and it'll make their job easier and you'll be a lot happier. Okay? All right, that's slide 51 on what you should have in a self-audit. Let's go to slide 53. This is what actually occurs during an inspection. And I guess, again, I'm kind of running out of time here, so I won't cover a lot here, but this is what DNR looks at during the inspection. I mentioned compost piles, etc. I'll leave that for your reading. If you have questions, let me know. And I think any questions on work plan inspections? Okay? All right. I'm going to move. Open burning. I said I had to mention it. Slide 57. Do not have burn barrels at your livestock buildings, okay? Do not have burn whatever it is. Burn site, whatever it is. Do not have that there. You can make an argument it's household waste. You might lose that argument if there's something in there that's not household waste. It's one of those that is kind of well, anyway, don't have them. If you have any questions about this, let me know. But it's one of those things you can avoid a check mark on your inspection form. EPA air emissions regulation, I'm going to move through that. Nothing's changed there. I'm now to federal law. And there was a district court decision where environmental plaintiffs alleged that EPA was required to adopt air emissions regulations for livestock operations, and it went, believe it or not, it went all the way to the U.S. Supreme Court, and the U.S. Supreme Court said, no, we're not going to hear the case. EPA has discretion here, and they have decided, and this is the whole air modeling or air monitoring requirements we've been through over the years, and the court said we're going to leave it up to EPA, and the environmental plaintiffs, you can't make EPA do it. We as a court, we can't make them do it. So I'm over on slide 63, Des Moines Water Works, 10 minutes. Okay? We're out of the area of livestock regulation, not that this won't apply to livestock, but this is not a DNR issue, this is not an EPA issue. At least the lawsuit wasn't originated by EPA. This affects all of farming. Well, anyway, you know that. Here's what we have. We have a lawsuit. I'm on slide 63. We have a lawsuit filed in District Court, U.S. District Court, Northern District of Iowa. And as I note there, I started out with slide 63 saying that for this lawsuit, there is no legal precedent, at least I don't see it, for this type of lawsuit to support what the Des Moines Water Works is claiming, that field tile lines out of a drainage district, but wherever those field tile lines are, that they are a point source. Now, let's go on over to slide 64 and let's go through a little more detail. The petition was filed in March. The trial was set for August 8th. On January 11th, you probably saw this in some of the media, the federal judge, this is a case in federal court because it's the Clean Water Act. And again, I said EPA didn't file this suit. DNR didn't file this suit. The Des Moines Water Works did, and they did it as a citizen suit saying, in effect, EPA and DNR aren't bringing this suit, they aren't doing their job, so we as citizens, being the Des Moines Water Works, and we'll talk about who they are, they filed this suit against the drainage districts. The federal judge, because it's a federal Clean Water Act case, the federal judge, well, that judge, if the trial were held on August 8th, which I'm pretty sure it won't be, but that judge will decide, are those field tile lines point sources that need a discharge permit? Just like we talk about a factory, just like we talk about a livestock operation that's a large CAFO that would need an NPDES permit if they discharge. What Des Moines Water Works is arguing is those tile lines need an NPDES permit, and limits what they can discharge for nitrates to the federal drinking water, safe drinking water standard, which is 10 milligrams per liter. That's what Des Moines Water Works wants. That's what the federal judge will decide. But before we get there, someone has to decide, can those 10 drainage districts in Sac, Calhoun, and Buena Vista counties be sued? Under Iowa law, because Iowa law establishes drainage districts, can they be sued? And we'll talk about that in a minute. The federal judge has said, well, that's a decision, that's an Iowa law decision, not a federal law decision, so therefore I'm going to certify it, kick it over to the Iowa Supreme Court, and the Iowa Supreme Court will decide those questions, okay? That has been done. The parties will file briefs, and there will be an oral argument, etc., and then the Iowa Supreme Court will decide Does this lawsuit go forward? Can those drainage districts be sued? And if the answer, and I'm greatly simplifying this, folks, but if the answer is, the best case scenario would be the court would say no. For the drainage districts and agriculture, the answer would be no, and the case would be over. But if the court say yes, they can be sued, like the Des Moines Water Works is suing them, then the case would go forward and go back to the federal judge, and the federal judge would then decide the actual issues on, I have on slide 65, that are discharges from a field tile line in these drainage districts point sources, okay? Slide 66. Let's talk about who's who here. Des Moines Water Works, independently owned and operated public utility authorized under the Iowa Code, cannot levy taxes, owned and funded by its customers. I've said this before, I'll say it. Unfortunately, folks, I'm funding it because I'm a customer of the Des Moines Water Works. I pay my water bill faithfully every month, and sorry about that, but I got to pay my water bill or I'll be in bigger trouble. It's owned and funded by its customers. Are the customers funding this lawsuit? Anyway, I think the Des Moines Water Works has stated on this website that there is a fund set up to support this lawsuit, as there has been a fund set up to help the drainage districts defend it. But the point is, it is not the city of Des Moines bringing this lawsuit. It is not the city council, etc. It is the Des Moines Water Works, an independent utility. The board is appointed by the mayor, subject to approval by the city council. There at the bottom of slide 66, Des Moines Water Works installed a nitrate removal facility in 1992. Before anybody raises their hand and says this, I will state, and this is the fact, that when the Des Moines Water Works takes nitrates out of the water, so it comes out of that water fountain out there where the nitrates have been removed, if they're operating the nitrate removal facility, they dump those nitrates and whatever else they removed back in the river. They do have a small facility, I understand, to store some of it, but by and large, all of it goes back in the river. Can they do that? Their NPDES permit says they can. They have an NPDES permit from federal EPA through DNR, and that permit says they can do that. So I'll leave it up to you. What I think the Des Moines Water Works realizes that is a quote-unquote Achilles heel for them, but it doesn't sit well, does it, to think they remove it and put it back in. Their point would be, not that I need to make their points, but their point would be, folks, we didn't put it there, we just put it back where we found it. We found it in the water and we put it back. I think they need to figure out a better way to handle this, but I better leave that one alone. Drainage districts, slide 67. Who are they? Authorized by the Iowa Code, as I said. The drainage district trustees, and the counties themselves are not getting sued that I named. It's the drainage districts in those counties, because the county supervisors are the trustees of those drainage districts. Just a quick primer, and I'm showing my roots here for what it's worth. Where I'm from and where I used to farm, we farmed both sides of the ground, so that meant we didn't have trouble getting rid of the water. You just found the nearest hill, poked it out into a ditch, and you were rid of that tile line water. Up where we're talking about here, this is flat ground, relatively flat, have trouble draining it, getting the fall for drain tiles to work. One landowner by themselves, we realized early on in the 1900s, cannot drain their land, so drainage districts were established where they go together, they levy taxes against themselves or levy assessments against themselves to build a joint drainage tile line, a joint county ditch, and they contribute towards that. What was the goal of a drainage district? Get rid of the water so we can farm the ground. The drainage district trustees will tell you, we're doing exactly what the code tells us to do, to get rid of the water. The code in nowhere says we should have any authority over what those landowners or how they're farming their ground, etc. That will all be a discussion in the lawsuit, believe me. All right? Water sampling, Des Moines Water Works sampled water in these areas from March 18th to December 30th. I'm running out of time, so I'll skip over some of this. Their allegations are that it's a point source. And here, to me, the lawsuit is all about this. Why did these drainage districts get sued? Why didn't they just sue any farmer, anywhere? We have the point sources over here that we know are point sources. Then on this hand, we have farm fields, which under federal EPA regulations have always been considered non-point sources and not regulated. What the Des Moines Water Works here did is kind of went in the middle and said, oh, wait a minute, we have these drainage districts that are unified, extensive engineered drainage systems, as I have on this slide. Kind of looks like an entity, something that is, again, legally formed, has been engineered, etc. So it looks a little closer to what has traditionally been a point source versus a farm field. That's, I believe, why these drainage districts were singled out, or at least drainage districts were. Right now, the suit is against these drainage districts. The suit will go forward. I don't believe any others will be added, but it is a case that is receiving national attention, and it has huge implications for agriculture. Stay tuned. We're all keeping track of it. The Iowa Pork Producers Association, along with the other associations, are doing various things that they can to help these drainage districts defend this case. Okay? All right, I'm going to skip the next slide. If I had more time, I'd get into it. Slides 71 and 72, which you don't have in your printout, those will be online. Truck washes. Anyone have a detailed question about truck washes, I'll be glad to talk with you. The legislation this year moved them over into the livestock permitting, the animal feeding division, and take a look. And again, I'm sorry you don't have these slides there, but there is an exemption established now. Let me back up to slide 71. That we've established a regulatory category for animal truck wash facilities, which are, they wash single unit trucks, truck tractors, semi-trailers, or trailers used to transport cattle, swine, horses, sheep, chickens, turkeys, or fish. Okay? I want to see the truck wash. Oh, never mind. I'll leave that one alone. I'll get myself into trouble. Okay. If here, and I realize, and the gentleman here taking a picture, I'll leave this slide up if you want to come up and take a picture of it. It'll be online here in a week or so. We have some small animal truck wash exemptions that could be very helpful for some of you putting up the truck wash that only does your own trucks, and the average total daily per day volume of wash water used isn't more than 2,000 gallons calculated on a monthly basis. Then you've got an exemption from a permit for that truck wash, some separation exemptions. Could be very helpful. If you're above that, the permitting process, I think, has been simplified by this legislation. Should be a big help. Sorry I went over my time. If you have questions, please seek me out. I'll be glad to talk with you. Enjoy the Pork Congress. Thank you.